So, good afternoon, everybody, and welcome to today's webinar. My name is David Mol. I'm a senior associate at Tilly King Gibbons in Cambodia, and I'll be the speaker for today's webinar. I'll be diving into design rights protection and enforcement in Cambodia. I will also discuss common pitfalls and practical considerations when enforcing rights in Cambodia, as well as recent developments and aspects of protection and enforcement. We hope you find the insights shared today valuable and thought-provoking. Before I begin, I would like to have a few housekeeping notes to help run this session run smoothly. This webinar is being recorded. All participants are currently on mute to minimize background noise, and you are encouraged to engage with us by asking questions, but you can do so by using the chat function. So the chat function will be located at the bottom of your screen, and you can place your questions there. At the end of the session, I will address all of the questions that are placed in the chat box, and if time is running out, I'll follow up via email to get back to you on your questions. As a last point, your feedback is incredibly important to us. So at the end of this webinar, a QR code will appear on screen, and you can take a moment to scan this and share your thoughts on the recording. So with that, I will get started with today's session. So today we're addressing design rights in Cambodia, and I am working mostly on enforcement matters in Cambodia. So I will discuss for a large part of the presentation on enforcement pitfalls and best practices. This is the agenda of today to give you a bit of a roadmap of what we will discuss. First, I will address why design rights matter in the Cambodia context. I will address the legal framework and some key definitions so we get through the presentation smoothly. And I will address the scope of design rights. So once you've registered your design right, what is protected? So what can you protect? What is protected? What rights do you receive upon registration? And I will briefly address the Hague system, which is a system for international filings, which makes for a more smoother filing process if you're an overseas design right owner. Then I will delve into the second big topic of this webinar today, which is enforcement mechanisms and remedies, including common pitfalls, best practices, and a case study. I will also address a recent development, including custom recordal, but also some other recent developments that are taking place in Cambodia in the field of design rights. So why do design rights matter in Cambodia, and why is it important to consider registering? Cambodia is a growing market with design imitation risks, and understanding of IP is still evolving, which means that there's sometimes bad actors that are capitalizing on this lack of understanding. This means that perhaps the consumer base is not yet up to speed on that design rights, and that some products are copies and not originals, but also the enforcement authorities and the courts can be still learning about design rights, how they work. So some bad actors capitalize on this and imitate products through a design imitation. In our experience enforcing in Cambodia, industrial design rights are the second most important form of IP. We say this because usually we rely on trademark registration and trademarks to enforce. But if there's no trademark use, we would see the design right as the second most important form of IP to rely on. And it will help you combat copies or imitations. A design right protects the product appearance, so it goes beyond just the trademark or the logo on the product. It protects the whole design of a product and the visual appeal of a product. So it is a little bit broader than just a small logo. And this will help you because certain products are more known by their design than by their logo. It protects the overall brand assets beyond just the trademarks. And this is important because design right infringement may lead to consumer confusion and hurt the brand just as much as a counterfeit does. If there is a copy of your product or a copy of your design, the consumer could see this as a product coming from your factory or your manufacturing process. So they will just be just as confused about the brand as a counterfeit can do. So it can do just as much damage if there's a design right infringement. We also see design right as a bootstrap solution. So if there's no trademark infringement, because you either haven't registered your trademark or the trademark is not used on the product, you could consider design right as an enforcement option that is available if there's no trademark infringement established. So that's why we call it a bootstrap solution. That is like the second sort of step that you can take. What is a legal framework in Cambodia? The main piece of legislation is the Law on Patents, Utility Models, and Industrial Designs of 2003. And there are two prakas, which are ministerial regulations that set out the procedures for registration. This was issued in 2006 and 2021. In 2017, Cambodia joined the Hague system, which is the international filing system, and we will address this system in more detail, but it's important to note that this happened in 2017. Then there's TRIPS compliance and ASEAN IP commitments. So these are international agreements or international commitments that will become important later on in this webinar, because we use it to interpret certain aspects of the law, or we use it to interpret how a registrar would look at the design right when it's deciding to allow the design or not. So it gives us some guidance, let's say, although it's not binding on the consumer directly. It will help us in enforcing. These rights are administered by the Department of Industrial Property, which we refer to as the DIP generally. And this is a department under the Ministry of Industry, Science, Technology, and Innovation, which I will refer to as MISTI later on. So if I say MISTI, I mean the Ministry of Industry, Science, Technology, and Innovation, but it's a mouthful. So MISTI is the shorthand. So what is an industrial design and a design right? Article 89 of the 2003 Law on Design Rights describes it as any composition of lines or colors, or any three-dimensional form, or any material provided that such composition, form, or material gives a special appearance to a product of industry or handicraft, and can serve as a pattern for a product of industry or handicraft, and appeals to and is judged by the eye. So two important points to highlight from this definition is appearance. So it is very visual. So appearance appeals to and is judged by the eye. So this right discusses designs and how it looks to the human eye. The protection will not extend to features dictated solely by a technical function. So as you see in the design right shown in the bottom right, it's an electrical bicycle. The wheels would not be protected. Why are the wheels not protected? Because this is a shape that is dictated by its technical function. A wheel has to be round for it to be able to function. So that aspect of a design right you cannot register, and it will not be protected. However, the rest of the mode of this bicycle you will be able to protect, because of the shapes and the design is unique. So what are examples of designs that are usually registered by brand owners or design owners? Product shape, so the whole shape of a product, like this bicycle here. Packaging, we see this a lot in automotive lubricants, for example, where you have oil brands that have a very nicely designed packaging that sets them apart from other competitors, and that would be something you'll be able to register. Then there's patterns and ornamentation. Ornamentation, it means more if you have a table, for example, but you add many designs and carvings to this table, this would be ornamentation. So a table as such is usually not registerable, but if you add all these extra features, it could be a design that you may be able to register. So that is called ornamentation. However, most of the designs we see registered are product shapes, so the whole product, like this bicycle over here, or packaging. So those are two key forms of design that are registerable and that are very well protected. So what can and cannot be protected? As discussed in the previous slide, shape, configuration, pattern, and ornamentation. That can be registered, but what is not registerable or protectable are purely functional features, like the wheel or in the past slide. What also cannot be registered are designs contrary to public order or morality. So there will be a test to see if the design goes against public order or morality, or is prohibited by any other means, for example, weapons. Then that design cannot be legally registered in Cambodia and will not be protected. The design must be new. So this is a test that is global. The design must be new from a global perspective, where the registrar will look on the date of filing, or the priority date, if the design is truly new, so you're not using anyone else's design, and that it is not published anywhere in the world yet. Only then you're allowed to have it as a design, because that means it's your own unique design and it's not a copy from someone else. So this novelty is assessed at the filing date. Then I mentioned the Hague system. The Hague system is an international system for filing through the WIPO. WIPO means the World Intellectual Property Organization, and Cambodia joined the Hague system under WIPO in 2017. What this means is that you can file a single application, one set of fees, and in one language, but you can designate multiple jurisdictions. So it means if you do one filing, you can choose 4 or 5 countries through that one filing, pay one set of fees, submit that one application in one language, and you have protection in those 5 countries. So this is really a simplified manner of getting protection across multiple jurisdictions. So for example, you enter the ASEAN countries and you're entering 4 or 5 countries, you could go through this one application to get registration and protection for your design right. If you have an already existing international registration, you can also add designations. So if you expand into a new market, then you can add another country designation to expand your protection in that market. But you can also follow the national route, which is a filing to MISTI, where you submit the documents there and you obtain registration for just Cambodia. So the Hague system is more international and multiple countries, or you do the national road through MISTI for just Cambodia. So what do you get once you complete the registration? You get the right to exploit under the law, which exploiting means making, selling, or importing articles or goods incorporating the design. So when you remember the bicycle from the previous slide, if you have a valid registration for that design, then I can make products with that design and sell them. I can make them and I can import them. There's an exclusive right that only belongs to me because I own the design. You will own the design for 5 years initially, and you have 2 times renewals of each 5 years. So the total years of protection will be 15 years. After that, there's no more design right to rely on, and it's not protected anymore, and anyone can use it. During that period, you have the right to license and assign the design for exploitation, which means I can give someone else the right to make, sell, or import those articles, and they would have to pay me for it. So you can monetize your design. So this is a strategy for designers that could design a nice product, nice looking product, and have someone else actually do the work exploiting of making, selling, and importing, but you can ask money for using such design. You also get the right to enforce against unauthorized third parties when they infringe your rights by exploiting your design without authorization. As discussed, you have the exclusive right if someone else uses it. If you have a design registration, you can go to the courts or the police or other authorities to enforce against such use, so that they have to stop or pay you damages. So again, exploitation means the making, selling, or importation of articles incorporating the industrial design. Once registered, you have the exclusive right to these actions, and you can sell that right to a license. So that is the main right you get from a design right in Cambodia. As said, there's 5 years from the filing date. The validity of the design right renewable twice. You have to renew, otherwise the rights will be lost. However, there's a grace period of 6 months after the renewal date, but you have to pay a surcharge. If you do authorize another party to use your design through a licensing contract, this must be recorded with the registrar. This means that you have to make a filing to the registrar to show, okay, I've let someone else given someone else the right to use my design. If you don't do that, then there's no effect against third parties, so you could not enforce or rely on the license contract. Similarly, changes in ownership must also be recorded and published. Otherwise, you cannot rely on your right if the change in ownership is not duly recorded and published. If you do not renew in time, you will permanently lose your rights, which means that the design right will not exist anymore. The bicycle example that I showed a few slides back is one that has not been renewed. I found it on the online database for Cambodia. It has not been renewed, so there's no more rights over that design. So that's why I used it as an example. So the owner of that design right did not renew and let it lapse. So there's a permanent loss of rights. So now I move to design right infringement. So on the left is a registered design in the US, and on the right is a copycat, as we call it, using that design. But it's not exactly the same, as you can see. There's minor differences. So how do we actually determine if there is a design right infringement? In this case, yes or no? So we have to first look at what is considered an infringement under Cambodian law. An infringement would be to exploit without consent of the owner of the design. Exploiting was making, selling, or importing articles incorporating the design. If you do that without consent of the owner, it will be considered an infringement. But then the question comes, what is incorporating the design? In the previous case, A and B, there's there's arguments to be made that the design is included in B, but there's also arguments to say there are differences. So what do you do? So it's quite difficult to determine if the disputed product is indeed incorporating the design. And the common defense from the other party, the infringer, would usually be to say it is not the same design, and they highlight a few of the differences. So then you have to overcome this defense. So it's a difficult test to use, and there's no case law in Cambodia to rely on because case law is generally not made public here. So how do we approach a suspected infringement is by presenting a strong case. This sounds logical, but many times when someone's rights or IP is infringed, they feel that there's something unjustified happening to them and that the authorities should take action. However, you have to be very proactive and gather a lot of evidence and present a strong case to convince the authorities to actually act. So my main concern is always when I help clients enforce their right is to invest enough money into gathering evidence and gathering enough arguments to convince the authorities to act while your rights are being infringed. So you can argue, why am I paying for having to fight this case? But this is unfortunately how it is at this point. It is important to highlight to authorities, if you want to convince them of an infringement, that it is a deliberate design choice. So if you look at the slide here where we see A and B, there's a couple of design choices that not all shoes of this type would have. So the holes and the placement of the holes and the use of the strap at the back, some of these are choices by design that not all of these type of shoes have to make. So if B uses that from A, you could argue, well, they could have decided not to use it, but they did. So if there's a deliberate design choice made by A and that is copied by B, then there is better arguments to say, okay, this is a infringement. So what we do is we set aside the technical features. We say this is a technical functional part of the design. So don't look at this, but some of these other aspects, I made them for my product, and another product doesn't have to follow that choice. And they did follow that choice because they're infringing me. So the deliberate design choices is something to highlight before authorities to convince them, yes, there is an infringement. So the infringement test for Cambodia, as I said, is quite difficult to determine. The critical term is incorporating the industrial design. So the law asks whether the accused article incorporates the registered design, which means the visual appearance of the accused product incorporates the design. So we're not looking at trademarks, we're not looking at colors, we're not looking at anything else but the visual appearance. So the design and the shape of the design for determining if there's an infringement or not. This test of incorporating industrial design and relating it to the visual appearance comes from the definition that I mentioned earlier, because this definition requires the design to appeal to and judge by the eye. So this means the judgment is visual. So we look at the two designs. Is there enough similarities to state, yes, it is incorporating the industrial design? So the test is not technical, it's visual. So given the structure of the law, the stronger the infringement cases in practice will be those where the product clearly reproduces, so near identical copy. The example I showed before there, it's pretty much an identical copy, but there are some minor differences. So we would have to argue those minor differences are not enough to say it is not incorporating. It is enough to say it is incorporating. So the closer the two products are in design, the easier it becomes to then argue before the authorities, yes, there's an infringement case and you need to proceed. This test is, as I said before, visual. The strongest cases are building on highlighting those visual similarities. So what does this mean in practice, these visual similarities and this test of incorporating the design? So practically, if I want to present a case to the enforcement authorities, I would conduct a side-by-side comparison to highlight all those visual similarities. I will buy a product of the accused product, so the product that is copying me, and I will put my design right next to it and show the similarities. I will also try to present a genuine version of my design. So you can see the design is just all these lines and composition, but how does it translate into a real product? If I put the accused infringing product next to the design and then next to the real product, I can quite easily highlight to the authorities, look, there's many similarities and they're incorporating my design. So the practical approach to meet the test of a design right infringement is a side-by-side comparison, and do that by presenting it visually. It's a visual test, so present it visually. In high value cases, you can consider a customer survey to ask customers what they feel. If they also feel like, yes, these are very similar designs or these are identical designs. Why a customer survey? Taking the ASEAN Common Guidelines for the examination of industrial rights, we can use the concept of overall first impression for the novelty assessment. So if the design is new or not, we have to look at the overall first impression, comparing designs as they appear to the consumer during the ordinary use of the product. So the visual similarities have to be similar to a consumer during the ordinary use of the product. So if you are in a high value case and you want to bring strong arguments that damages should be paid to you for the infringement, you can do a consumer survey and see if all the consumers agree that during the ordinary use of the products, they see it as the same design, or the overall first impression is that it is the same design. So these are like practical steps of meeting the technical infringement standard that was difficult. The ASEAN Common Guidelines for Examination of Industrial Designs technically apply to examination and registration rather than enforcement, but they are good guidance, let's say. So there's a lack of guidance in Cambodia, so we have to find guidance wherever we can. And the ASEAN Common Guidelines that Cambodia has endorsed can be used. And in addition, it follows the same structure as the law in Cambodia, where the appearance and the visual judgment is key. However, it adds the consumer aspect. So it is key to whom? To the consumer during the ordinary use of the product. If they see it as visually similar, then you would meet the test of it being a design right infringement. And then you can take the case to the enforcement authorities, or you can take your first own enforcement steps. So enforcement means you have the exclusive right, someone else is using your right, and you want to take steps against that person. You want to enforce your rights, exclusive rights against that person copying your product. What you can do is set out on this slide. You can obtain a formal infringement opinion from MISTI. So I was talking about the visual side-by-side comparative analysis that you can do by putting photos next to the design and photos next to the genuine version of your product. You can present this to MISTI, the Ministry of Industry, Science, Technology and Innovation, and request for their formal opinion if this is indeed an infringement. If it is an infringement, they will issue a formal letter confirming this, and this can be used when you send a cease and desist letter to the other party. So when you send a cease and desist letter, you ask the other party to simply stop using your design. But if you attach that opinion, you have a bit more, let's say, support and legal support to claim that there's an infringement. If the cease and desist letter doesn't work, you can go to an administrative proceeding, which is a dispute mediation session also under the ministry. Now, the cease and desist letter, coming back to that, many people think, oh, this is a weak approach and it's not strong. But in Cambodia, it works almost 80 to 90% of the times. If you send a cease and desist letter, the other party is notified of the design right infringement, and the party is notified that you will be, you have the appetite to take action. So if you send such a letter, most of the other parties, they take their money and run, and they think, okay, I don't want to have a prolonged case. I will just stop using this design right, and I'll give up. So the cease and desist letter is a very valuable tool in that sense, which is often overlooked. Many people want to move directly to the police or directly to the courts, but actually the first step through a letter is very, 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 very effective. the letter doesn't work, dispute mediation. If that doesn't work, you could take your complaint to the authorities. So an infringement complaint to the authorities would mean requesting the police or customs or another similar enforcement authority to take action, which usually is to seize the goods in a raid. So a raid means they go to the infringer's location, the stock location, they find the product with your copied design incorporated, and then you say, okay, let's seize this as evidence and send the case to court. It means that the infringer is being stopped from selling, which is a good step. Plus, you have the evidence in hand. And you have the evidence in hand in terms of stock. So if there's a big stock, you have bigger claims for damages because more stock means more damages to your design right. After a complaint to the enforcement authorities and a raid action, there's usually a criminal court case. So if you file a complaint to the authorities, it's a criminal complaint generally in Cambodia, which means you trigger a criminal proceeding, which may lead to a court case down the road. You can also settle the case earlier, but generally it does lead to a court case after a raid action. In other countries, you have an administrative raid, which means they just seize the products and issue a fine or similar, but not in Cambodia. It is the starting point of a criminal court case. Civil court proceedings are also possible. Civil court proceedings are possible when you want to seek damages. So if it's more about seeking damages and not about seeking a criminal, let's say you're not seeking criminal action, but just payment for what damage has been done to you or IP rights, then you would do a civil court proceeding. But as part of the civil court proceeding, you can also request preliminary injunctions or injunctions to stop an ongoing or imminent infringement. This means that I file a case to the court, I want to seek damages, but during the court case, I ask the court to say to the other party, please, they're not allowed to sell during this court case. Until we have resolved this court case, they're not allowed to sell my product, because if they sell out, then all the infringement enters the Cambodian market and I have a bigger problem. So that would be a preliminary injunction you can get at the beginning of the case, and then you follow the whole case through to get actual damages. So damages and compensation for an infringement can be part of a criminal and a civil proceeding in Cambodia. So even if you do the raid action and the prosecutor in Cambodia is prosecuting the infringer, you can be part of it as a civil party in a criminal case and ask for damages there. Most of the brands would also seek seizure and destruction of infringing goods, which is you request the court to take the goods off the market, take the goods out of the stock warehouse and destroy them so that they cannot enter the market. Other options are to modify the goods. So for example, you have an infringing motorcycle, but the main part of the body of the motorcycle is still usable if they did not use the design elements. Then you could also resort to something called modification, so that the design is not used anymore, but the overall product is still being allowed back on the market. So then I'm going to look at criminal penalties. So criminal penalties, Criminal penalties are part of the law of design rights. So criminal penalties include fines from 5 to 20 million riel, Khmer riel, that translates to, I noted it down, $1,250 to $5,000. So the fines are between $1,250 and $5,000 per one offense. But there's also imprisonment, and of course the imprisonment measure is penalty is a stronger mechanism to use. But it also means that if you file a complaint to the police and they raid, that person that is raided can end up in jail. So that is good to know from the beginning. Okay, what are my goals for this case? Do I want damages or do I want to put someone in jail? But yeah, it's a strong tool to stop people from infringing for the threat of imprisonment between 1 and 5 years. If you're a repeat offender, penalties will be doubled. Border measures are also available, and a border measure you do through customs. A border measure means that I am aware of a shipment coming into Cambodia or leaving Cambodia, and I ask custom to suspend that shipment pending an investigation into those products in that shipment to determine if they're counterfeit or not, infringing or not. So the rights holders for a border measure should only take action when they have strong evidence. So you have to know, okay, what is the container? What is the container number? When is it entering? Can you suspend this specific container? And then can we inspect it for design right infringement? So this is pretty hard to realize in practice because many times you don't have all this information. But now customs has a custom recordal system, which I will address later, where customs will ongoingly look out for design right infringements. But for now, the rights holders must initiate action with strong evidence only. So only when you have all the evidence in place of information about the infringer, but also strong evidence of the infringement. So you have to have the side-by-side comparison again that I mentioned before. Customs recordation allows ex officio detention of suspected infringing goods. This means that customs officers, if you have recorded your design right in the IPR recordal system, customs can then, even if they see it without your notification, they can stop the shipment and then request you to join an inspection. So that's called ex officio action. The custom officer takes it out of their own initiative. So border measures or any raid action must always follow with a court case. So if there's a border action, a suspended shipment, either by your own request or by the customs itself, after the inspection, you must follow with a court case. If you don't follow with a court case, the goods will be released. So under Cambodian law, there's always a court case that follows. So you always have to file a complaint to the court, which is something not all jurisdictions have in Asia. What are some of the key enforcement authorities? So you have a problem that is not resolved through the letter or the mediation sessions, and you want to still enforce, you would go to the Anti-Economic Crime Police Department, or AECP. The AECP is the department under the National Police of Cambodia, and it has its own Anti-IPR Crime Bureau. The AECP generally handles economic crimes. And then the Anti-IPR Crime Bureau is responsible for all IP crimes. This includes trademark infringement, design right infringement, but also copyright infringement. They're like the one-stop shop where you file a complaint. They will do investigations, then conduct a raid. A raid is conducted to gather evidence. So this evidence is then taken and submitted to the court. So the prosecutor attached to the court will review this evidence and then decide to either file criminal charges or not file criminal charges. So the police is the first steps and the starting point for a criminal court proceeding, but a criminal court proceeding will 90% of the times follow after this action. Another key enforcement authority is Customs, the General Department of Customs and Excise, or GDCE, under the Ministry of Economy and Finance, and we usually call it Customs. It handles border measures, so suspended shipments, and you can request as a rights holder to suspend a shipment of import, but also export based on the design right registration in Cambodia. This is the starting point for a court case as well. This can be criminal or civil. But as said before, if you do an action with customs and requesting them to stop a shipment, you have to follow up with a court case afterwards. So we go back to our example and look at okay, what will be the steps in practice that we take to go from, okay, we spot product B on the market, we own design right A, we see product B on the market. What do we do? What are the steps we take if this happens to you? So you first check if your design right is valid and registered, and if you have the evidence by way of a certificate. So when you register your design right, you get a design right certificate with the design shown on it, and it shows the validity. This is a certificate that you have to present to the court or to the police to ensure that they will take steps to protect your right. So the first step, always check the design right, the validity and registration. Then you have to meet the infringement test that we discussed, the visual test of determining if it is incorporating your design. So we would usually recommend you do a purchase sample of the accused product, and you make a comparison both between accused product and the design right, and accused product and a genuine version of your product. So you can show the similarities, and you can even overlay them sometimes to show, okay, look, the composition of lines is exactly the same on the accused product. Once you are sure, okay, there is a design right infringement, what is my next step now? How can I stop people from selling this infringing product? So you have to identify the target that you want to action against. So this is very simple. You have to find an importer, you have to find the seller, or you have to find a manufacturer that is actually doing the copying, because otherwise there's no information for the police to go after. The police does do their own investigations, but generally you have to present quite a lot of information and targets to them before they actually go there. If you just submit, okay, my right has been infringed by this product, can you go and find it? That will not work. So you have to identify an actual target through in-depth investigations, and you can then also determine how much are they selling, are they Are they a sophisticated party that I can take to court for damages, or is this a very unsophisticated party and maybe I can only stop them from selling, but there's no monetary damages to collect? So usually when we identify the target, we do an investigation. We check for sale location, one or more. How much volume do they sell, estimated? What is the stock location, and how much do they have in stock? If it's a company name, who's behind it? What's the identity of the owner? And then we will have to get photos evidencing the exploitation. So we have to get evidence to present to the police. Yes, this target is making, selling, or importing products incorporating my design. From that point, you have to consider your strategy. Usually, we recommend first a cease and desist letter, but you can get the DIP infringement opinion, the formal opinion from the government authority about infringement first or after. It depends a little bit on fees and cost, but we would usually recommend to get it in advance because it makes your case stronger. Then you send a cease and desist letter to that target. In certain cases, you skip the cease and desist letter if it's a very big target and you know they're going to hide all the products if you notify them. But 99% of the times, I would recommend the cease and desist letter first because it usually resolves the cases. So as said, it's recommended to get the formal opinion because if it's favorable and you send a letter, you have a much higher chance of cooperation. If the CD letter is ignored, the cease and desist letter, we have to reconsider what evidence do you have and what are your goals. Do you want to stop the sales, or you want to get damages, or you want both? If you want to stop sales, you should do a police complaint and raid the stock. This is the easiest and quickest way for police to go down there, take the infringing stock, and close the sales location down pending the case. So that is an easy way to stop the sales. However, damages are a bit more hard to recover from this process. If it's a sophisticated target and you think there's significant damage to obtain, I would recommend going through the civil court proceeding, because in a civil court proceeding, the damages is a large part of the whole case. In a criminal case, damages for the victim are actually only a small part of the proceeding. So depending on your goals, stop sales or get damages, you can go either to the police or to the civil court. So what are some of the common pitfalls we see when people are trying to enforce their design rights in Cambodia? So the first one is, of course, failing to register. So if you don't register your design right, you have no rights in Cambodia to rely on for design protection. Another pitfall is relying on an old design while the actual product in question sold is been updated many times because it's a newer or more current model. So sometimes the newest model that comes out is quite different from the design, right, registered 10 years ago. And if the copy is more of the new model and not the old design, it's hard to convince the authorities to actually take action against the copy of the current model. Another common pitfall is not investing in obtaining sufficient evidence prior to the complaint. So this means that to cut costs, sometimes you don't want to invest in getting a lot of evidence and getting the comparison done by a high quality photographer, for example. But then later on in the process, there's not sufficient evidence to convince the authorities. If you have to go back at a later stage to get evidence, sometimes the evidence has moved, the evidence has changed, or the situation has changed. So it's always good to stop and think early on in the case and like, okay, do we have all the evidence to survive a prolonged case and win this case in the end? And a common pitfall is actually cutting on the early stages of obtaining evidence. For example, not requesting the opinion from the MISTI or the DIP. You can enforce without this opinion, but it's very powerful in enforcement matters. So we usually recommend to get this product to get this opinion at the outset. So some of the best practices we've learned from enforcing in Cambodia is register early. Cambodia follows a first to file principle. So this means, register your design rights as early as you can, because if it's published anywhere else in the world, it's not new anymore and you cannot file anymore in Cambodia. If you're an overseas brand owner or design owner, you can use the Hague system for efficient multi-jurisdictional filings, and ensure you use high quality drawings and clear descriptions. So it is easier to show the design right in high quality drawings and descriptions to the registrar, but also to enforcement authorities. It's always good to monitor the market proactively for infringement, but this is the same for trademarks or design rights or any type of IP, to monitor the market proactively. And my main best practice would be to build a strong case early on. So you invest in getting evidence, you do the side-by-side analysis, you might consider doing the consumer survey that I mentioned before. And that way you can also identify infringers that are worth targeting. So you need to, if you want to collect damages, you need to show you need to ensure that the target actually has monies to collect. So also the early on investigations can sometimes show that the party you're targeting will not have many monies, or is not rich enough to collect damages from. So it's maybe not worth it to fight this case all the way through through the courts. And then one of the points I always want to highlight is the DIP infringement opinion. It's always good to include it, but many brand owners or design right owners consider it's not important. But in my experience enforcing in Cambodia, it is important to use this opinion. Consider warning letters in negotiations. So this is what I said earlier. Many of the cases in Cambodia are resolved after a warning letter. So it's always a good point to consider using this warning letter as a first step instead of going directly to the police or the courts. Why would I avoid the courts? Because there's no case law, so it's very difficult to predict the outcome. And we're not sure how familiar the courts are with design rights because we don't know how many design right cases they have handled in the past. Part 2 of the best practices and strategies is to record all your license agreements and ownership changes. Otherwise, you don't have a right to rely on. If you license it out or you change the ownership, this has to be registered. Otherwise, there's a discrepancy between the owner on paper and the owner in reality. And then the owner in reality cannot enforce. It has to be the owner on paper on the certificate. So you have to track renewal deadlines carefully. This means that because if you don't renew in time, you will lose the right. So renewal deadlines should always be carefully followed. Consider complementary protection. This means, okay, if you have a case where you're being copied, you can consider using trademarks and design rights and unfair competition claims, as well as consumer protection claims to convince the authorities to act. So it is not only trademark or only design or only consumer protection, but consider this as a holistic case that you can use multiple avenues of legal support to enforce your rights. Maintain organized IP portfolios is always a good idea, regardless of it being design rights or trademarks. But especially portfolios are used to track renewal deadlines carefully, because if you miss the renewal, then you can lose the right. Engage local counsel is always a good idea in Cambodia, because local counsel has a good idea of what type of CD letters work, what type of language works well with authorities. So that's always a good strategy. Then I will address the recent developments. So there's an official industrial design rights database now launched in Cambodia since 2024. So everyone can go in the database and check for design rights, including their own, but also of others, to see if there is a design right already registered. A big step is IP rights recordation system with customs. So they had a trademark recordal system, but now it's been expanded with design rights, and it's been expanded with design rights as a matter of a pilot project in 2026. We had a case with customs early 2026, and customs saw that we wanted to rely on a design right, and since then they added it to the customs recordal system. So we're very proud that we helped expanding the protection of design rights in Cambodia through one of our case studies leading to the inclusion. There's increased international cooperation with overseas and international organizations such as WIPO, EU, IPO, and JPO on the design right front, and especially JPO is very active in Cambodia on helping the authorities and helping the government to expand design right protection in Cambodia. There's a national IP policy, and there is more appetite, of course. So this is the last point, I think, is a good point to know. The last 2 years, we have seen more appetite of the court, police, and customs to actually enforce based on design rights, where in the past they were not always too excited to use design rights because they didn't understand it. But we see it now as something that is recently developing, and that's why we wanted to have this webinar going to inform our clients and future clients that actually you can use design rights very well in Cambodia and protect them very well. So these are some of the key takeaways. Registration is essential. Enforcement is improving but remains challenging, so be strategic. the design, right, and trademark together work best. So that is the multi-layered IP strategy that we talked about earlier. And early and regular engagement with experienced local counsel is critical, as always, in Cambodia. That is it for today. Let me go to the next slide so you see my email address. This is my email address, davidm@tiliki.com. So if you have any questions, you can always reach out to me there, and I'll be happy to answer them. So I hope this session was informative for everyone, and hope to see you in our next IP webinar session on June 9. Thank you very much, everyone.